Good evening, everyone, and welcome to tonight's webinar, the 2026 Special Needs Trust Workshop. My name is Sandy Irwin. I'm Director of Family Supports at St. Louis ARC. So without further ado, I'm going to turn it over to our presenters tonight, Vivek, Casey, and Michael.
Great. Thank you, Sandy. I'm going to kick us off. I'm Bhavik. I've been a special needs planning attorney for over 20 years, and I've been giving a lot of these presentations. So thank you all for joining. Um, we have three awesome panelists today, and we're going to all kind of talk about aspects of special needs trust. But before I even get into any part of special needs trust, I always want to level set and talk a little bit about the basics of public benefits. So that's what I'm going to kind of cover today is the public benefits, why a special needs trust matters, and then kind of break down a little bit of the different types of special needs trusts, and then end on some common pitfalls, common things we see that could jeopardize your loved one from receiving public benefits or maintaining public benefit eligibility. So I'm going to share my screen and kind of go through here a little bit of a PowerPoint I put together. What I want to talk about is public benefits, like I said earlier, and ultimately I want to focus on sort of two major ones, but I want to step back for a second, just kind of give you the broad categories of public benefits that are out there. So as we talk to people, sometimes they get some of this confused, and I just want to be very clear here. There's on one end, there's benefits not based on financial need. And then on the other end, there's benefits based on financial need. So those are sort of the two broad categories of public benefits we're going to talk about. Um, those that are not based on financial need are your good old fashioned Social Security, or often also relevant is Social Security disability income. And then there's Medicare and special education. Again, these are not based on financial need. On the other end of the categories, those that are based on financial need, and the two big ones that often come up in most of these conversations are SSI or supplemental security income and Medicaid. There's some other ones like housing subsidies or food stamps or utility payment assistance or legal aid and things like that, but I'm not going to really talk much about those. Kind of going here, I'm just going to kind of define supplemental security income for you. So, what is SSI, which is not SSDI? I'll kind of briefly talk about that later. But SSI is a federal program that's administered by each state, and it's a financial uh, aid that is provided based on proving two things. One is disability, and the other is financial need. Okay, so I'm just going to kind of pass by the disability part of it and talk a little bit about the financial need. But before I do that, what is SSI intended for? And the thing I want you to know, it's pretty restricted money, and it's specifically and limitedly used for the individual with the disability, their food and shelter needs. There's not much more you can use with it. There's a few things, but I mean, generally, I want you to take from this presentation. Think about SSI as a way for it to provide financial aid for food and shelter for your loved one. Um, Often I refer to the loved one with a disability as Joey, so I might do that here. So I just wanted to give you a heads up if I just start saying Joey, that's what I'm referring to. So it's restricted money and it's based on disability, proof of disability, and financial need. There are two relevant tests for SSI eligibility. There's what we call the income test, and then there's something called the resource test or the asset test. And the way I want to describe it for you is if you think about a door, you're behind a door, and on the other end of the door is the world of SSI benefits. The first test we want to think about is the resource test. That's the test we have to pass in order to unlock the door. The second test, which is the income test, is the test we want to pass to see how wide that door is going to be open. So if you never pass the resource test and never unlock the door, you really don't get into the other part of it, which is how much of a benefit I'm getting. So if I step back for a quick second and say the resource test is what's unlocking the benefit. So that's the test that I really want to really spend a lot of time focusing on. And that's also the test where the special needs trust becomes a very big, valuable tool to be able to make sure or ensure that Joey continues to make sure that door is unlocked. So, as we talk about the resource test, one might ask a very initial question, which is, what is a resource? And what I want you to think about when you think about what is a resource, I want you to start here. I want you to start with saying a resource is anything that can be converted to cash. At a high level, that is literally everything. Everything could be converted to cash. A t-shirt you're wearing could be worth a penny, so it could be converted to cash. That's where I want you to start. Later on, I will tell you some exceptions to that rule of some resources that are not looked at. But for now, I want you to just think about resource, meaning everything that Joey has. And I'm going to also say it depends on how old Joey is. If Joey is a minor, then they also look at mom and dad's resources. If Joey is an adult, then they start looking at Joey's resources. So as I talk about this, depending on how old Joey is, you might have to factor in what mom and dad's assets are versus just Joey's. So for SSI, and I have a typo on my slide, I apologize, but for SSI, the resource test is this. If Joey has assets, resources, in excess of $2,000 on the first calendar month in which Joey applies for benefits, then that door remains locked. So what does that mean? So today is April 16th. If Joey applied for SSI today, they're going to look back on April 1st and see what Joey's assets are. And if Joey's assets are less than $2,000 in total, then Joey gets to unlock the door. Assets that Joey does not have a legal right to are not assets of Joey. That statement right there is the power of a special needs trust, and Joey doesn't have a legal right to demand those assets. He's the beneficiary of that trust. He's able to use those assets when the trustee decides to use them for Joey. But because Joey doesn't have a legal demand to say, give me X, and the trustee has to do it, they're not assets of Joey. And so that's the power of a special needs trust. The other thing I want to point out is if you qualify for SSI, you will likely qualify for Medicaid, except for there's a different resource test number for Medicaid. This is where my typo is on this slide. My apologies. But way back when, it used to say $1,000 for Medicaid is the resource test for Medicaid. It is. It's a little bit over $5,000 now. So I just wanted you to be aware of that. So, but the number I actually want you to take away from this presentation is the $2,000 number. Because if you could qualify for SSI, you're going to be able to qualify for Medicaid. If you focus on the higher number Medicaid has, you might still be disqualified from SSI. So I really want you to just think about $2,000 being that threshold. Okay, I told you earlier, there are certain assets that sort of are exempt resources. They don't add up to being part of that $2,000 threshold. So what are those assets? One is a home that Joey has an ownership interest in and actually lives and serves as if it's his or her principal residence. So Joey has to live in the house and it has to be his primary residence. Well, if Joey ever has to leave a home for his care, maybe be put into a group home or some other type of facility, then all of a sudden that residence is no longer exempt. I do not recommend leaving the home in Joey's name, even though today's topic is really specifically about special needs trust. It's just not a very good estate planning strategy because if Joey no longer lives in the home, it's gonna lock the door. Another exemption is household goods that Joey might own, like the personal property inside the home, like the iPad, where altogether it's worth no more than $2,000 in market value. These exempt resources I'm reading to you are literally what are in the law. Um, if they're not, if I don't say them today, then they're included. Okay, they're not exempt. But why I'm mentioning it is there's some things that people focus on more versus not. And in my experience, the household goods is not really one that SSI really focuses on or Medicaid really focuses on because it's really hard to prove who owns the household goods, who owns that iPad. Maybe mom or dad actually owned it and not Joey, and Joey just uses it. So I don't really spend too much time worrying about that particular. Oh my God, Joey has so many things and he's going to get disqualified. I don't really worry too much about that. Um, but I wanted you to know what technically the law says is the exempt resources. Another one is a vehicle, an automobile. That vehicle is um, absolutely necessary for Joey medical treatment or a modified for operation, like a handicap accessible van. Then the entire value, no matter how much it costs, is completely exempt. However, if it's not necessary to perform the essential daily activities, then there's a cap to the market value of that vehicle before it's exempt. And that's so if the vehicle is worth more than $4,500, then it's no longer exempt. So be careful having the car owned by Joey unless it's something that is absolutely necessary to perform essential daily activities. A few more exempt resources that are important: life insurance policies that have less than a $1,500 cash surrender value that is owned by Joey. So I'm not talking about mom and dad owning a life insurance policy. I'm talking about Joey owning a life insurance policy. A prepaid funeral or prepaid burial arrangement, that is an exempt resource. And then the last two are the most popular because these are the things that people talk about the most. An ABLE account, as long as it doesn't have more than $100,000 in it. And then assets in a properly drafted special needs trust. There's no dollar cap to it. So there could be $100 million in it, or there could be $5,000 in it. If it's a properly drafted special needs trust, that is not part of Joey's resources for the resource test. So that really highlights like why a special needs trust is important, because if you have one and it has assets, you don't have to worry about how much assets are in it because they're not going to disqualify Joey from public benefits. They're not going to lock the door or shut the door or anything like that. So that's the resource test, but I'm going to spend a second to talk about the income test. There are three major types of income. There's no slide on this. I'm just going to talk about it. There is what we call, like service income, like you go work, clock in and clock out, and you get a paycheck. That is earned income. That is income. Another one is what we call unearned income, which is, interest earned in a checking account, or if their mom and dad are divorced and a child support payment is being made. These are what we call unearned income. And then there's a third income, which is called in-kind support or imputed income. And this one is the one that's really tricky that people don't think of when they think of income. So if Joey is an adult and he's living with mom and mom and dad are not charging him rent, the SSI is going to look at what the value of that rent is, and they're going to impute that value to be income to Joey. So you have to be very careful because here's basically what you need to understand about income. It's pretty common sense, but the more income Joey has, what do you think's happening to the door? It's shutting. And if he has too much income, the door will be shut. Right? So we all want to encourage independence. We all want to encourage Joey to have the best life possible. And if he can make the money and he has income to where it shuts the door, that's not necessarily a bad thing. But I just wanted you to understand, got to unlock the door. And then you got to look at all these different income tests or types of income to see how much that door is going to be open versus closed. And it's sort of a balancing act of all of understanding all of that with how independent Joey can be, or that we're trying to get him to be in terms of working, things like that. Okay, so what is the purpose of a special needs trust? I've already kind of alluded to it. It's a way to provide private funds to Joey such that they don't disrupt his public benefits. That's the magic of special needs trust. There's lots of ways for funds to be put in a special needs trust. You'll hear a little bit about that from Michael later. But I mean, it could be money that mom and dad put into it. It could be money that grandma and grandpa put into it. It could be because of an inheritance. Lots of ways money can make its way into a special needs trust, such that when that money continues to grow, it's not disrupting those public benefits. So that's sort of at a high level, an overview of SSI. And remember, if you qualify for SSI, you qualify for Medicaid. Medicaid's the very important public benefit that really highlights a lot of additional extra services that can be provided for Joey that many families have found to be absolutely invaluable for Joey's care. And so maintaining eligibility is a very powerful thing because we don't know what needs or what help or what services Joey might need down the road potentially. And so keeping those doors unlocked will help you have all the options to consider what might be best for Joey. Okay, so the last slide I'm going to talk through before I hand it over is these common pitfalls, these things I see families do all the time that create a potential pathway for the door to get locked, for public benefits to either be reduced or completely be disqualified from them. So I just kind of want to highlight these 5 things and then kind of inject where potentially some planning opportunities could come in. And then we'll go on to a little bit more of a deeper discussion of what types of special needs trust there are. And then we'll hand it over to learn a little bit more. So real quick, transfers to Minors Act accounts. Like my kids, when they were young, got birthday gifts and birthday checks and things like that. And then I would just go throw them into a what's called a custodian account or a uniform transfer to minors account, or those types of accounts. Well, I did not mention those types of accounts as being exempt. So you have to be very careful. If you have these accounts and they're starting to grow, they can potentially go towards that inevitable path of locking the door. So I just want you to be aware of that. Some people might just say, you know what, let's not even create those accounts, keep them in mom and dad's name, and then mom and dad can use the money for Joey. That's a great technique. Another technique could be to create a type of special needs trust that can receive money now. And then that's where the checks are being written and deposited to so that that can continue to grow. and there could be savings, an abundance of money for Joey to be used and not have to worry about the disruption of public benefits. So those are kind of two ways you could tackle that transfer of the Minors Act account issue that we just see all the time. Another one is unstructured beneficiary designations. So this is, you have a 401k or you have an IRA or you have some kind of employer benefit that pays out if something happens to you. You might even have a life insurance policy, either by something you got on your own or something your employer provides. And when you kind of start your job, you are going through the onboarding, they give you forms, you start filling them out. We see oftentimes people put as the default beneficiary designations my spouse, and then the secondary beneficiary they put my children. Well, if Joey's one of your children, that creates a uh-oh moment, right? Because now Joey might get an asset that will disqualify him from public benefits because it'll exceed the resource test. So what you really want to do there is think about changing those beneficiary designations, and maybe what part would have gone to Joey in whatever order you put him in the beneficiary designations is, instead of it being Joey, put the special needs trust for Joey. That way it would be there for Joey, it will stay there for Joey, and it will absolutely protect him from losing those benefits. The next one is directing funds to be held informally by another family member. I see this all the time. Joey has a sister, her name is Emily. Mom and dad just leave everything to Emily, so it's not in Joey's name, doesn't disrupt public benefits, and they're just trusting that Emily will take care of Joey. Well, I'm a glass half full kind of guy. I think that probably would happen, but there are some things that you need to be aware of with that strategy. One in particular is when you leave that to Emily, it's there for Emily's use. So, if Emily got in a car accident and there's a lawsuit against Emily, that money is exposed. If there's creditor issues, that money's exposed. If Emily were to get divorced, that money is exposed. So there's a lot of unintentional vulnerabilities with this strategy. And it just doesn't make a lot of sense, because why take that chance? Why is Joey bearing all the risk here of Emily isn't able to provide those funds because something happened in her life that was outside her control? I really, really try to discourage anyone I talk to about this strategy. The better approach, in my opinion, would be to leave it in a special needs trust. You could name Emily to be in charge of it, so she can still oversee it. She can make all the decisions for Joey's benefit. But now if something happens to Emily, no one can touch those assets. So it's there. It's protecting Joey, which is why all of you are here today. So please do not disinherit Joey. It's just not an effective strategy. Another thing we see is, grandma or grandpa wants to leave Joey money. It's a beautiful thing. It's a great thing. But if you're not having conversations with your other family members who might want to do something for Joey, it could be a really negative consequence. So many people walk into this trap, so to speak, where grandma or grandpa leaves Joey money. They didn't think about it. They don't know some of these rules, and they just thought they were doing a nice thing. And now Joey has this inheritance, and boom, the door is locked. That's what we're trying to proactively plan against, is we don't want Joey's door to be locked. So here is another example of a special needs trust that you could create. And then you can have these conversations with all these family members that want to do these wonderful things for Joey. and then just direct them. Instead of leaving it to Joey, leave it to the special needs trust we created for him. That way he can actually use it, utilize it to really supplement his life and to do things beyond what the public benefits will be for. Otherwise, that money is just going to dissipate through core needs and not enrichment needs. And that's the key. We want to enrich Joey's life as much as possible. And the last one is moms and dads. If you don't do any estate planning of your own, the state in which you live in, I presume most of you live in Missouri, Missouri has written an estate plan for you. And many people don't know what that Missouri estate plan says. And what it says for a mom and dad is if one of them dies, mom or dad's money will be split half to the surviving spouse and the other half to their children. Well, if Joey again is one of the children, we just hit another one of those uh-oh moments where now the door is locked. So doing nothing, doing no estate planning will result in a very likely probability of Joey being disqualified from public benefits. It's sad that that's what the law is, but there's nothing I can do about that. So I just wanted you to be aware of it. I think it's critical. You have to do something. You have to do the planning. The planning doesn't have to be a everything under the kitchen sink kind of approach. I mean, it could be very narrowed and targeted to make sure that the assets that are going to Joey are going into that special needs trust. But you have to have an overarching estate plan that says what happens to your assets. And if you don't, there's a problem. We do have an estate planning workshop, so join that if you want to learn a little bit more of the estate planning. The last thing I want to talk about is the categories of special needs trusts. Just a little bit of a broad education on it. And then Casey, then I'll hand it over to you. So these aren't technical ways of describing. If you start Googling this, you're not going to look at what I'm about to tell you. I'm just kind of talk to you real and kind of in lay terms about the types of special needs trusts. There's two broad categories. There's the reactive category, and then there's the proactive category. Okay. And just like you might think, reactive means you're reacting to an uh-oh moment, a problem. And now you're having to fix it and you're having to react. So it's not the ideal scenario, but you need to know that a reactive type of a special needs trust exists. And then there's the proactive type, which is clearly not reacting. It is putting a plan in place that allows for the most freedom and flexibility to use these special needs trusts for Joey. All right. So in the reactive zone, so to speak, the major type of special needs trust is called, and it has many names. Some people refer to it as a self-settled special needs trust. Some people call it a first party special needs trust. Some people call it a Medicaid payback trust. There's a bunch of names for it. They're all kind of doing the same thing. It's reacting to a situation where Joey has now received assets that are causing him to be disqualified from public benefits. So we want to take those assets and put them into those Medicaid payback trust. That's what I'll refer to it as here on out. Well, the good news about that is there is still this reactive tool that allows you to unlock the door while Joey is alive. The bad news of one of these types of trusts is if there's any money left over when Joey passes away, they need to go to reimburse the state for all the money and services they provided for Joey. That's the catch. And in my experience, those trusts are more scrutinized, and how you use the funds during Joey's life are much more scrutinized and much more audit likely. And so like I said earlier, reacting is not ideal. Sometimes we have to do it, but it's not ideal. So that's sort of the reactive zone. The proactive zone, there are two types of special needs trust, but they're both called third party special needs trust. By the way, first party or Medicaid means it's Joey's money that he already has, and he's putting it into that trust. Third party means it's someone else's money. It never was Joey's money. It's mom and dad's money, grandma, grandpa's money, Uncle Billy's money. It doesn't matter. Someone else's money that is being placed into this trust for Joey's benefit. So, like I said, that's a third party special needs trust, and there is no payback provision. So, no time does any of that money have to go back to the state to reimburse them for services or money they provided for Joey. That's why it's superior. That's why it's proactive planning. Now, there's two types of third party special needs trust. One is called a testamentary, and the other one is called a standalone. They do the same thing. It's just when is it created is the distinction between those two. Testamentary means it's created upon mom and dad's passing. It's part of their estate plan, and it doesn't come to life until mom and dad's inheritance goes into it, which means mom and dad have passed away. That's what testamentary means. Standalone means it exists the moment you set it up and you do it. That way, and the big question you have to ask yourself for which one of those two you want is you have to ask yourself, is it possible Joey is going to receive money, not from his job, but from someone else prior to mom or dad passing away? If the answer to that question is yes, or likely yes, or yeah, I think that could happen, then you need a standalone special needs trust. You need to prepare one. You need to get one set up so it's ready to receive those assets when someone directs those assets to that trust. So if the answer to that question was no, you can do a testamentary special needs trust. But that's the broad categories of special needs trust. There's more, but that at a high level, that is sort of the breakdown of all the special needs trusts. So at this point, I'm going to pass it on to Casey for you to talk about special needs trusts and the administration of them.